be dealt with together with the objection that we want to take to that affidavit?
Yeah, because of time, I want him to make the two requests. And then when you raise your issue, you will raise it and also respond to his request.
Can I reserve my response to the request of the augmentation of Mr. Barre's deposition to when I make my objection?
That will be the way you may elect. But I think the decent way would be we allow him to make the request, and then you object to that request in response, so that we are able to make a ruling on it.
Thank you very much.
Okay. Senior Counsel, how many minutes?
I will take less than 5 minutes.
Oh, thank you. Proceed.
Mr. Chairman, we wrote to this committee on Tuesday, 11th May 2021, as part of the housekeeping rules, and we informed them two things, basically, that our witnesses will be 3. We gave them their names so that there is full disclosure on the same. But we also intimated to the clerk and this to this committee that we want this committee to summon 4 witnesses that are critical to the fair trial and disposal of this matter. Without them, this trial will not be a proper trial. You have the powers, you have the rules. The first witness, Mr. Chairman, as you can see, is the governor's, or the first lady, governor's wife. The second one is the governor's son. The third one is the governor's daughter.
Maybe as you give the names,
yes,
you can also tell us maybe the area where you need them to come and clarify, if you are able to.
Yes, yes. Mr. Chairman, the county assembly's case revolves around the family of the governor. It's our evidence, and we will adduce enough evidence to show that the governor, his wife, and his children have played such a pivotal role in the degradation of governance in the county government, in the misappropriation of public funds, in breaking down of structures of governance, and that they have ruled this in an ad hoc manner. They have ruled the county of Wajir in an ad hoc manner, outside the constitutional architecture of governance. In that process, their presence is indispensable. Your Honor, Mr. Chairman, a trial that does not call the First Lady cannot ventilate properly the issues we are raising in this. She is the epicenter. She is the eye of the storm. She is the foundation of the issues that was raised both in the petition and in the witness statements here. So, the daughters and the sons that are of very pivotal importance in this matter. You have the powers, Mr. Chairman. It will not take a lot of time to summon them. Summon them,
yeah,
and
so
let us have.
It's good. You have said daughter and son, so we should tell us B is daughter, C is son, so that we.
Yes, A is the first lady.
Yes.
B is the son. C is the daughter. D is a man whose fingerprints appear in every transaction that the county government of Wajir has done. He owns so many companies. He has won so many contractors. He has been awarded so much money that Mr. Osman Abdi Jimale must, in my humble submission, be summoned here. He's a treasure trove of evidence. There is not one company, Mr. Chairman, who was not awarded contract that his name doesn't appear.
Are those companies part of the?
Yes, they're part of our evidence. We are putting the CR12 as part of our annexures.
Okay.
So we have laid the basis.
We have a bundle of documents. If you can just point that the connection is in bundle C, just for.
Yes, they are attached to the.
Just make reference to the bundle.
Yes, yes.
Where we get those CR12.
Yes, they are attached to the to the witness statement of Mr. Shoaib. Mr. Shoaib is our second witness, yes, witness number 2. He's the representative of Diff Ward, and his affidavit has all the annexes. Oh. Yes, and I think, according to your record,
You'll bear with us. You know you brought boxes of documents, so we are
yes,
trying to trace.
CS7.
CS7, eh?
Yes.
I have the document, so you can refer to the pages where the CR. I can see from if we move together.
Yes, sir.
From page 34.
Mr. Chairman, can my learned friend Hanan show you the pages?
Okay.
Yes.
Council, you can just point us the page.
Chair, my apologies, I'm reaching the page.
Speak to the mic, Council.
Honorable Chair, it appears at page 38. In
Page
support of the witness,
38.
page 38, correct.
Okay, that's
And
Luyu
appears-
General Contractors.
That is Laley General Contractors Company Limited.
Okay.
And then it also appeared at page 39.
Page
That is
30.
Dayo,
That is Dahayo Construction and General Supplies.
correct. And it also appears at page 40.
And then at page 40, that is Laceland General Merchants.
Correct, Chair.
Any other?
Chair, we've also made reference to it on the affidavit and witness statement of Honorable Abdullah Ishaq, the mover of the motion.
Okay. Sorry, I know the documents are many, but is there, can you pinpoint maybe where they were awarded contracts? Is it also here?
Chairman, if you will allow me with your very kind permission to interject. This is one of the depositions that we wish to take up a preliminary issue on. And it is prejudicial to the governor at this juncture for substantive material, such as an allegation of award of contracts or any microscopic examination of a CR12 to go on record.
We are not taking any details. We just want to see the basis upon which this request is being made. We are not making any determination at this stage at all. Yeah. So, Council, is there any page you want us to look at?
That's it, Chair.
Is there any?
No,
None.
ma'am.
Okay, so Council, Senior Council, you are done?
Yes, for that point of summoning the witnesses, we are done. I'm guided by you whether I should add or reply or join with my learned friend when he's taking the more substantive objections here.
Can you conclude on the request for further affidavit and annex?
Yes, Your Honor, on the further affidavit, my humble submission is that we are not raising any new evidence. What we are doing is that we inadvertently misplaced some annexatures to that affidavit. We are not bringing new evidence, so it's just an issue of annexing this new document. I have looked at your rules.
So that the record is clear, which affidavit are you talking about? Is it the same C7?
Yes, that one of Shoaib. We forgot some documents on that. Shoaib Barre Ahmed.
You are referring to the affidavit of Barre Ahmed, CS7.
Yes. Yes, so if you look at that statement, Mr. Chairman, you will see from page 1, from page 1 to page 21, page 1 to 21.
1 to
Yes,
page 1?
1 to 21.
Okay,
Yes.
I'm with you. Yes.
Yes, there are certain bank statements, transactions that are there. So within those bank statements, there are certain documents or certain pages we forgot. We forgot. And if you look at paragraph 26 of the witness statement itself, paragraph 21, are you there, Mr. Chairman? Paragraph 26 of the witness statement, we say annex here to unmarked SBA 1 are the following documents, and they run from A to L. Unfortunately, we forgot a very critical annexure, that is A.
A.
Yes, a copy of Mrs. Khaira Umar's statement account for the year. This one is very crucial. It shows you a lot of evidence on how kickbacks were paid, how money was received, the nexus between that company, we were talking about the companies by that witness, the transactions. Then, Your Honor, what we will do for ease of reference is that we did a chart like this, which gives you, the movement of the money from what account to which account, from what company to which company, and how it all ended up in the banks of Mrs. Khaira Umar Malim.
So the application, if I hear you right, is that you inadvertently forgot to include annexure A.
Annexure A, yes.
Okay, that's
Yes,
it. Okay,
yes.
that's clear.
Yes.
That's all?
Yes, that's all. And we have it here. My learned friends will have ample time the whole of today. Because their case is tomorrow, they will have ample time to reply to that, to interrogate it in depth. So there will be no prejudice, absolutely none, that they will suffer.
Very well. Members, I think you can follow CA7, paragraph 26. The request by Council for the County Assembly is that they inadvertently forgot to attach annexure A. So when we retreat, you can bear that in mind. Okay, then Council for Governor, I will allow you to make your response and also raise any preliminary issues that you have. And Senior Councilman Nasir, one member wants a clarification. Senator Linturi, proceed.
Yeah, Chair, with the tremendous respect to Senior Counsel, I think I would wish that you would further clarify whether the document intends to introduce is a statement of account or is a bank statement.
Thank you very much, Senator. Yes, it's a statement of the bank, yes, relating to certain account of the witness, which we forgot to add.
Senator, that's clear?
Yeah, it is clear, Chair.
Thank you. So, Councillor Nyamodi, you can respond to the issues raised by Senior Councilman Nasir.
Thank you very much.
And then you can also raise your PO so that Ahmed Nasir will respond, so that when we consider them, we do one direction on all of them.
Thank you very much.
Yep. How many minutes?
Chair, 10 minutes.
Okay, very well. Proceed.
Chair, just to start by responding to the request for a further affidavit, it would have been easier to respond to learned Senior Counsel if we had had an opportunity to see what he has taken such great pains to describe in such graphic detail. Chair, members of the committee, I urge you to note that even as the request is being made, we have not had sight of this monumentally important document that was omitted when this affidavit was being put together. So in respect of what it is or what it is not, or whether it completes what is already in the deposition, having had no sight of it, we are unable to make any comment on it. But Chairman, what is more important is that according to the program that you read out at the beginning of this morning's proceedings, it is the County Assembly's turn to present its witnesses once we conclude with the preliminaries and you make your determinations and give directions about objections. Chairman, what Learned Senior is saying is that they want to introduce new evidence now. And they then want the witness to testify now, because today is their day, they have no other day in which to lead evidence, and they then wish the governor to respond to that evidence at whatever time the governor chooses to respond. Chairman, needless to say, that is a prejudicial position to the governor. There is no clearer example of an ambush. Evidence cannot be produced during the hearing because the hearing commences today, because the governor has no opportunity not just to consider, but to respond as he is entitled to. Chairman, the affidavit in respect of which that evidence is sought to be adduced to augment or the evidence contained in that affidavit is important. And Chairman, I wish to refer you and members of the committee to pages 34 to 40 of the annexures to that affidavit. And I just wish you to note, Chairman and members, the dates of those CR12s. CR12s are records from the company registry in respect of directorships and shareholders of companies. Chairman, you will note that the CR12s are dated on various dates between the 9th and the 10th of May this year. Chairman, this evidence could therefore not have been before the Assembly when the Assembly sat to consider the motion of impeachment at the end of last month. What this evidence is, and I will argue that point substantively when I argue my objection, is an attempt by the County Assembly to expand the scope of the motion of impeachment facing the governor. So, Chairman, other than the fact that it is an ambush, it is an attempt, unlawful and constitutional, to expand the scope of the motion. And Chairman, for those reasons, I urge that this committee denies the request by Learned Senior to augment the evidence and by extension expand the scope of the motion for impeachment. I now, Mr. Chairman, wish to respond to the first issue, and that is the letter dated the 11th of this month requesting for certain witnesses to be summoned. And Chairman, I wish to oppose that request, and I wish to commence my opposition to that request by pointing out to Mr. Chairman and the members of the committee the important words in Rule 9, that the committee may. And I wish to emphasize, Mr. Chairman, and I wish to make the submission that if the committee may, then the committee also may not. It is not mandatory, it is discretionary. And I wish to submit the following reasons why the committee should not summon the witnesses. First, Mr. Chairman, the relationship between the first three witnesses, A, B, C, and the governor. It is the governor's wife, son, and daughter. As a matter of law, Mr. Chairman, whereas those witnesses may be competent to testify against the governor, with tremendous respect, they are not compellable. And what the summons seeks to do is to get this committee to compel them to testify against the governor. Their husband and father in both instances. Mr. Chairman, I will leave it to Mr. Ndegwa in a moment to highlight the relevant provisions of the Evidence Act.
Mr. Chairman, wish to proceed from where my senior has left. We oppose vehemently the application to summon those said witnesses. As indicated, there is no basis that has been laid by the applicant as to why those witnesses might be called upon to appear before you. Mr. Chairman, I want to invite you to look at the Oath and Statutory Act. And while you look at that act, Mr. Chairman, and the committee, we invite you to look at the rules of the court under Section 6. And you, Mr. Chairman, then you'll go to rule number 9, which deals with the question of exhibits. It provides that all exhibits to affidavit shall be securely sealed together under the seal of the commissioner and shall be marked with serial letters of identification. Mr. Chairman, what has been presented before you is just a mere allegation that they fall in between the affidavits. You have been told that those documents fall between annexure A and something. Are they capable of being effectively distinguished as prescribed by Rule 9? Even as they appear before you this morning, do they comply with that rule? Mr. Chairman, an affidavit is a statutory oath. It's oath. It is guided by this act, Mr. Chairman. And any procedure that offends this act offends the entire process. Mr. Chairman, may I submit on the question of the compellability of this witness? And as I do so, Mr. Chairman, I refer you to the case of Governor Wambora, Civil Appeal number 21 of 2014. In that case, Mr. Chairman, the Court of Appeal at Nyeri was able to distinguish these processes. And it is said when it was settling down on the question of the standard of proof, the court said that it is not on the balance of probability, it is not above reasonable doubt, it is there in the middle. Why was it there in the middle? It's because of the quasi-criminal nature that these proceedings invite. And when you look at the quasi-criminal proceedings, Mr. Chairman, you might then want to look at Section 127, subsection 3 of the Evidence Act, on the question of compelling a witness, and more so a spouse. That provision, Mr. Chairman, says that that witness can only be admitted as a witness at the election of the person charged, not at the election of the person who is charging, in this case, the county assembly. Mr. Chairman, we submit that that provision bars and all prohibits a spouse from testifying against the spouse. Mr. Chairman, you might want to ask the foundation of that provision, and you'll find it in the Constitution. It provides that the family is the fundamental basis of every fundamental unit of every society. And if then we are to summon the family members to testify against their father, the question then that be, and it may be a legal question and a social question, is the future cohesiveness of the society. Mr. Chairman, as I sum up, you have been told that these documents will come relevant during the proceedings. That is mere speculative. The applicant is on a fishing expedition. Why is he on a fishing expedition, Mr. Chairman? There is no witness who has testified before you to lay basis whether these individuals participated in that procedure. How and why should the applicant, the county assembly, be aided by this committee to summon witnesses? Have they demonstrated that they have done it and the witnesses have probably abandoned or rejected to honor the summons? Mr. Chairman, there must be equality of arms. And this equality of arms, Mr. Chairman, is the provision of Article 27, equal protection before the law. the governor is equally protected before the law as much as the applicant is protected, Mr. Chairman. And then you might also want to invite yourself when you're looking at this application under Article 50. The question of fair hearing.
You should wind up.
Yes, I'm just winding up.
I'm told your time is up.
I'm just winding up. Article 50 is an underogable right under Article 25. And when you say that, Mr. Chairman, the applicant ought to be granted time and or opportunity to summon witnesses, the question will be, where shall the fair hearing aspect be left, noting that the witnesses will come and testify towards that document and will not have an opportunity of cross-examining them on the content of that document. I oblige.
Thank you. Senior Counsel, before you respond, Nyamodi, as the lead counsel, I had also given you leeway. If you have any preliminary issues, you raise them now so that when Senior Counsel responds, he responds to all the issues, because we are trying to manage time. So do you have any other preliminary issues?
We have other preliminary issues.
Yes.
And may I claim 25 minutes of time in respect of our preliminary issues? Now,
you know, we can't give you 20 because our timetable accorded you only 15. So you can take 15.
Thank you very much, Mr.
Yeah, you 15, and you must conclude all the issues within those 15 minutes. And time begins running from now.
Okay, so Chairman, we will be quick about it. I will commence my preliminary issue by winding up one quick issue or tying up one loose end that was left hanging in respect of the letter that we have just submitted on. In respect of witness number D in that letter, if I heard Learned Senior correct, he said that the intention is to establish that he is the owner of various companies. I believe that is done by the CR12. There is no need to call an owner or a director or shareholder of a company to prove that he owns the company. I submit that that request to call an owner and a shareholder in the face of such clear CR12s is an attempt, the only thing it would achieve would be to embarrass that witness. And that is the reason why this committee should not summon him. In respect of the preliminary issues, Chair, that we have in respect of this matter, I had indicated that we have 3. We have addressed 1, and now 4 remain. The first issue is, Chair, we wish to object to the inclusion on the record of this committee's proceedings today of the affidavit of Shoaib Bare Ahmed. It is the affidavit that we have discussed or has been discussed at length in the submissions that commenced with Learned Senior's request for improvement or augmentation of that deposition. Chairman, I wish to state first that the testimony or the evidence contained from paragraph 1 to paragraph last of that affidavit was not before the Assembly. The evidence that was before the Assembly was supplied by the Senate to the Governor on the 30th of last month. And the Governor has responded to that, or to the allegations and to the evidence that was shared with him by the Senate exhaustively. Mr. Chairman, I will repeat for the purposes of emphasis the submission I made a few minutes ago, that this affidavit was received maybe about 8 p.m. last night, and this witness is meant to testify today. There may be responses to the allegations that are made in that affidavit, but there is no opportunity to respond in the time frame in which this committee is proceeding. I submit, Mr. Chairman and members of this committee, that a party seeking to impeach a governor is therefore under the obligation to ensure that before the Assembly they present all the evidence that they wish to adduce in support of their motion for impeachment. And that, Mr. Chairman, then enables the governor to have his full Article 50 rights responding to those allegations. Mr. Chairman, it shouldn't be lost to this committee's mind that what is at stake here is the governor's governorship. And the committee should then give him all the opportunity to defend himself. And allowing evidence such as this, substantive evidence such as this, to be brought before the committee at the 11th hour and served on the governor at the 11th and a half hour without an opportunity to respond is prejudicial to the governor. Again, Mr. Chairman, I submit for emphasis that this is another attempt by the County Assembly to improve or to expand the scope of the grounds for impeachment. Yes, the allegation may have been made in the motion for impeachment that was before the Assembly, but the evidence was not presented before the Assembly, and it only arose last night. So, Mr. Chairman, members of the committee, our request, our preliminary issue is that the affidavit of Shoaib Bare Ahmed be expunged.
Okay, the next issue.
Be expunged from the record. Secondly,
Very well. Next.
there is evidence that falls into the same category, and that evidence is contained in the County Assembly's bundles, marked on the top left-hand corner as CA4 and CA8. On the front of CA4 is indicated Education Department 2015-2017, and in respect of CA8, ICT, Fisheries, Trade Department, Public Works, Environment, Agriculture. Again, Mr. Chairman, this is evidence that was shared with us or with the governor's legal representatives only late last night. This evidence does not arise from the length and breadth of the motion for impeachment. As I have previously said, there may be very well answers. The governor may very well have answers to the documents that are produced in these two bundles. But having not been given an adequate opportunity to respond, noting that the witnesses are due to take the stand once these preliminaries are concluded, to allow these documents to remain on record is prejudicial to the governor, and it limits his Article 50 rights. I leave the rest of the time for my learned friend, Mr. Ndegwa Njiru, to urge the remaining preliminary issues that we wish to take up.
Thank you, Council. Council Ndegwa.
Mr. Chair, I just have to pick up from where my senior has left and refer you to affidavit by one Hussein Abdurrahman Dahir.
Are you on the same issue?
Yes, just proceeding.
Okay.
And it appears as CA1, to which we are making an application, Mr. Chairman, that running all the way from paragraph 28, and there are two affidavits, that is CA1 and CA2, to the last paragraph of the affidavit be expunged from record.
Who is the author of CA1?
Mr. Chairman, the author is, the deponent is Hussein Abdurrahman Dahir.
CA1, eh?
CA1, CA2.
Proceed.
Mr. Chairman, the basis of this application is premised on the House Standing Order guiding these provisions, Rule number 19. It provides that in presenting its evidence, the County Assembly shall not introduce any new evidence that was not part of the allegations against the governor by the county as funded by the Speaker of the County Assembly, the Speaker of the Senate. Mr. Chairman, what this presupposes, Mr. Chairman, is that within the 2 days contemplated under Section 33 of the County Government Act, the period prescribed for the Speaker of the County Assembly to forward the resolution, it is a presumption under this rule of the Senate that the same must be accompanied by the evidence that the County Assembly is seeking to rely on. Mr. Chairman, if you just read that provision, it says, new evidence that was not part of the allegations against the governor by the County Assembly as funded. The operative word here, Mr. Chairman, is as forwarded, not as filed as at yesterday. Because if you look at section 33, subsection 2, it's the one that refers to the question of forwarding the evidence. So, Mr. Chairman, anything that was not received as at the time the County Assembly was forwarding this document can only be regarded as new evidence, and hence the question of admissibility comes into play. Mr. Chairman, all those paragraphs that we have cited and as annexed in that affidavit were not before the County Assembly at the time of the moving of the motion. Where is the evidence, Mr. Chairman? The County Assembly hands. And Mr. Chairman, one cannot have his cake and eat it. Equally well, one cannot be in a fishing expedition and expect the assistance of this committee. I refer you to the case of Honorable Philomena Mwilu versus the DPP, petition number 295 of 2018. In that case, Mr. Chairman,
all those cases, are they in your bundle somewhere?
Mr. Chairman, you know these are preliminary issues that I've just raised.
Mr. Chairman, these are the issues we have. My learned friend is citing cases. He has not given us a citation of. We don't know the authenticity of the spin he's putting on.
Diego, you know you are a very experienced.
He's breaking so many
you are a very experienced advocate, and you know.
Mr. Chairman,
courtesy dictates.
I
you are making reference to an authority.
I'm well guided.
And I presume you knew you will make reference to it.
I'm well guided.
You should have shared with the same with your learned friends.
I'm well guided.
Counsel, yeah?
I'll not refer to the case.
Yes.
But
Thank
Mr.
you.
Chairman, it's cardinal rule of any criminal procedure, even of this one, which is quasi-criminal in nature, that prosecution is not to be made good. It must appear to be good at the time of its inception. And appearing good, Mr. Chairman, is making sure, again, there is equality of arms, that the procedure complies with the doctrine of the fair trial, so that this doctrine of fair trial may not compromise the governor's presumption of innocence. What then that means, Mr. Chairman, is that these paragraphs, as indicated, will only lead to embarrassing the governor, and the governor will not have the opportunity of substantively responding to them. I move on to the other point, Mr. Chairman, which is the question of the competence of the motion before you as originating from the County Assembly. Mr. Chairman.
So that's another issue now.
That's another issue.
Okay.
While this committee is competently capable of dealing with the issues, the question of the competence of that motion comes into play. And the competence is the legal competence. And why are we impugning the competence of this motion, Mr. Chairman? It's because at the time of the debate at the County Assembly, there existed a valid court order arising from petition E009 of 2018, which was filed before the Meru High Court. What did the Meru High Court do? The Meru High Court injuncted the processes of the debate. Why was it injuncting, Mr. Chairman? It was injuncting because we were impugning on the legal ability of some officers to participate in that process. And in the wisdom of the judge found it fit to injunct the process. So the fundamental question is whether then an issue that arises from a process that has been injected by the court can then form a competent basis of an impeachment. Mr. Chairman, we argue this knowing very well that there exists a doctrine of checks and balances. The doctrine of checks and balances does not necessarily mean that these organs will operate in utopia. There must be a balance of each other. And that is why Article 165, Clause 3D, provides that the High Court has jurisdiction to interrogate whether anything said to be done has been done in accordance with the Constitution, whether there is compliance with the Constitution, Mr. Chairman. And so, Mr. Chairman, an impeachment is a constitutional process. And it being a constitutional process, Mr. Chairman, it is under the interrogation of the High Court. And that is why the High Court, in that wisdom, wanted to evaluate and interrogate the entire process, whether it sits well within the Constitution. Mr. Chairman, I move on to the other question about the issues appearing in the notice of motion. Suffice to note, Mr. Chairman, that some of the issues forming the basis of this impeachment are issues that are competently before issues before the County Assembly, which are pending resolution. Mr. Chairman, if you look at Standing Order number 89 of the County Assembly of the County Assembly of Wajir, and you read that standing order together with Section 14 of the County Assembly, of the County Government Act, Section 14A, which empowers the County Assembly to legislate the standing orders, you realize that that standing order bars the Assembly from debating any matter that is before a committee. Was that issue raised by the before the Assembly? Yes. We refer you to the standing orders of the Assembly, which we assume they have served you with. An issue was raised by one Honorable Rashid Mohamed as the competence of that motion. And what did the Speaker say? The Speaker said, "Order, Honorable Member, if that matter is before the committee, stop discussing it." So you go straight to what is in the motion. The question is, could then the Assembly find the governor culpable for issues that were before the committee? At that particular time, did the Speaker guide the Assembly as to what issues contained in the motion that may be voted for or against, or did he abscond his duty? Mr. Speaker,
I'm told you are
as I sum up,
our timekeeper there.
We urge you-
your time is up.
we urge you to find that the motion before you is not competent, that the governor's presumption of innocence and the question of equal protection before the law will be violated if then these processes moves on. At the fullness of time, Mr. Chairman, and we are not impugning the jurisdiction of this committee. This committee has power to check on the abuses of their sister or their brother county assemblies through the doctrine of oversight. Much obliged.
Okay, very well. So, Senior Councilor Nasir, you need to respond to
Yes,
those appeals.
I will respond, but just
And,
as a preliminary, I think. My Lord, Your Honor, I think.
How many
Chairman,
minutes do you require?
Maybe 15 minutes. I will be done.
Okay.
I think,
Can-
Mr. Chairman, we
you-
have to
Senior
discount
Council,
the.
Senior Council, can you do it within 10?
Okay.
Time is not with
Yes,
us. Really.
Mr. Chairman, I think we need to discount the high-sounding legal cliches my learned friend submits on, which are completely irrelevant to these matters. You know, separation of this committee. But, Your Honor, before I go substantively, there is an issue you told me and said, is there any rule that addresses this issue completely? And that's Rule 31. That gives the chairman absolute powers to rule on all these matters and address them in a most appropriate manner. But, Mr. Chairman, there is a very serious matters my learned friend are raising it for the first time, and it is a grave danger to the rule of law. They are telling you that a governor can commit all kind of crimes through his children and wife, and you can't summon them because, as my learned friend put it, the unit of the family will be compromised. The unit of the family will be compromised. In other words, everybody will be committing offenses through their wives, through their children, and when the law wants to take its course, you'll be told, no, 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 this is the wife, this is the husband, let us not destroy this family. What will happen to accountability? What will happen to constitutional accountability? Will we hide under the cover of spouses, daughters, and sons, as my learned friends submitted? I mean, I'm surprised that council can make that kind of argument, that let us not call the wife of the governor, let's not call the daughter of the governor, let's not call the son, because it may create some disharmony in that family. What of the public? What of the Kenyan public, whose money was misappropriated in this process? What happens to the law? I think that's an argument that's not even worth to make it in the first place. Your Honor, my learned friends also say that we are adding new evidence, and they cite Rule 19. Rule 19 is very important, but contrary to the submissions by my learned friend Degwa, the material word, Mr. Chairman, is this. It is this. Was not part of the, it says, in presenting the evidence, the Assembly shall not introduce any new evidence that was not part of the allegations. So as long as we have made allegations in the County Assembly, we can adduce evidence. And all these allegations that the governor's wife is the de facto ruler, that the daughters and the sons were given, all those issues, Mr. Chairman, are part of the petition that was taken to this. There is nothing we are adducing in terms of new allegations. My learned friend also took issues with the CR12. Of course, the CR12 was made on 9th and 10th, but that's not manufacturing new evidence. That's just retrieving documents that are on a certain web page. And because we were taking instructions, Your Honor, you look at that, the person who was requesting is my learned friend, Ms. Hanan. She just wanted to confirm the assertions by the client that Jim Ali appears in all this. So she just retrieved that document. The facts existed. The fact is that he was a member of that company, that he was a director, he was shared, existed. The mere fact that you retrieve evidence that exists in a certain database is not manufacturing of evidence. Your Honor, my learned friend again in Degwa, he refers you to the Evidence Act, all those. The Evidence Act, this is not a criminal trial. This is a constitutional inquiry on whether the governor should be removed or not. When my learned friend takes you all those rules, of course he knows that they are not relevant. Of course he knows that they are of no use. But he still recites for whatever purpose he does. So I urge you to discount all those issues my learned friend submitted before. He also, that's why I said he used a lot of cliches. He talked about the balance of probability, the quasi-criminal nature of these proceedings. We will talk about that. We have not reached yet. It is just premature. So, Your Honor, all these issues my learned friend are saying that you should expand from the record. You will have a proper time when you can determine that issue. When our witnesses are called, when you look at the original petition before, then you will make a determination, no, this was not part of it. But I can give you my word that we are not introducing new allegations. We are not introducing any evidence that was not before. And my learned friend's vehement opposition on this should be dismissed in limine. Yes, I think, Your Honor, I think that really
They have raised appeal on a pending matter before court. Any comments?
Yes. I mean, my learned friend also knows that even the courts themselves, and if you look at the ruling by the Speaker of the County of Wajir, which my learned friend praised it as high-sounding and appropriate when it was read. It's in the Hansard. This is what he said, my learned friend. This is my learned friend. He says, Your Honor, let me read what he said. He says, thank you, Mr. Speaker and distinguished Assembly. My name is Ndego Njiro, and I'm advocate of the High Court of Kenya. And with me is my learned friend Mwangi. We have heard your ruling, and we highly respect it because it is constitutionally sound. that is a statement. I'm not making it. He said it is constitutionally sound. And why is it constitutionally sound? Because, Your Honor, the Speaker rightly made the ruling that whereas the High Court has supervisory jurisdiction over Parliament when it made a decision, and that is even, I'm not disputing that, the High Court has made ruling that you cannot micromanage Parliament. You cannot intervene in proceedings that are ongoing on. You cannot stop Parliament to debate what it wants to debate. That is a red line on the sand. And that is the tradition of the Commonwealth. I mean, whether it's in England, whether it's in Canada, whether it's in Australia, the courts have said that their jurisdiction is triggered by a decision of Parliament. They have no jurisdiction to stop Parliament or to micromanage. And that's why my learned friend in Ndegwa said that jurisprudentially, the Speaker's decision was sound. I'm not surprised that he's changing his stand depending on the forum. But that's not what council should do. If you say it was sound in Wajir, it must be sound in Nairobi. All the objections, Your Honor, to the affidavits are inappropriate. This is not the right time. Let evidence be adduced. Allow us to put the evidence which is critical for this, and let us proceed, Your Honor.
Okay, thank you. So now you have raised a number of issues that the committee will require to retreat to consider them. But Councillor Nyamodi, I see you have put
Yes,
your mic on.
In the submissions we made a reply, we made a response to the two preliminary issues that Learned Senior had taken up, and we also urged 3 or 4 preliminary issues of our own, which Learned Senior has responded to. I was hoping, if possible, to claim 2 minutes as a right of reply, having moved preliminary issues that have been responded to by the other side.
I hope you are not misleading, Chair. I thought you responded to his appeal and then raised your own.
And raising my own, then
You have a right of
entitled me
reply. 2 minutes.
to a
2
response
minutes.
to
2 minutes.
whatever he said.
Yes, limited to those issues only. 2 minutes.
And it is really just a single issue. And it is to contextualize Rule 19 of the rules of this committee. The purpose of Rule 19 is to be seen if you look at the invitation from the clerk of this assembly to the governor. In the invitation that is forwarded by the clerk of this Senate, I'm sorry to call it an assembly, the invitation forwards to the governor it forwards to the governor the motion and the evidence in support of that motion. And that forwarding in good time gives the governor an opportunity to respond to the allegations and to respond to the evidence. Rule 19 should therefore be given the interpretation that then makes it possible for the governor to respond. And the word, let me get the word. The word allegation in Rule 19 should be read together with evidence, because allegation, evidence, and opportunity to respond. Rule 19 seeks to prohibit an ambush, and Rule 19 should at no point be interpreted so that it is facilitative of the kind of ambush that the county assembly seek this committee to be an accessory to. Thank you very much.
Okay, thank you. As I was saying, you have raised a number of issues, preliminary issues that will require that this committee retreats to consider and then give its ruling on the way forward. But I just want to ask, do you intend to make any opening remarks? Senior Councilman Nasir?
Yes, we want to make extensive opening remarks.
What about Council Nyamodi?
Yes, we intend to make opening remarks.
Yeah, so I will give this direction so that we manage time. We will sacrifice our lunch hour to do a ruling that will give a direction on how we proceed on all these preliminary issues, the witnesses, whether to accept the request or to reject the implication of that court order, and all the other issues. So I think I'll give you an opportunity for the remaining period. You make your opening remarks, and then during a lunch hour, we'll prepare our ruling on the issues you have raised, which we will deliver in the afternoon before we start on the trial. In that case, then I will allow counsel for the county assembly to make his opening remarks.
Chair.
How many minutes do you need? You have
On the upside, can we say 20? But I think I will make less than that.
you
Chair,
can
Chair,
make less.
point of order.
Okay, that's okay.
Chairman.
Proceed.
Point of order, Chair.
Yes, Senator Sakaja.
Thank you, Chair. I appreciate the situation we're in, with COVID-19, but council from both sides are a bit muffled behind their masks. Maybe you can direct that as they present, they can use the dispatch box so that we can hear them clearer, especially for council for the governor, because he's surrounded, but council for the assembly doesn't have anyone around him. You can remove your mask so that we can hear you a bit clearer, kindly, Chair.
Okay, Senator Sakaja, earlier on we had directed that nobody should speak without their masks on.
They're muffled, we can't hear. There's no reason to have a proceeding where we don't hear.
If we can rearrange the sitting, maybe the person next to the dispatch can move to the right, then we can allow your senior counsel to go to the dispatch. You make your remarks from there. Is that okay for you? Is that okay for you? Yeah, you can do it from there. Thank you. So he says he needs 20 minutes, so you can 20.
Honorable members of this committee, we are most honored and grateful for this opportunity to present the case of the County Assembly of Wajir in this process that entails the removal of the Governor of Wajir, Honorable Ambassador Mohamed Abdi, which you all know was triggered by the impeachment process that was started by the County Assembly. Mr. Chairman, this process is important both to the people of Wajir in particular and the Kenyan general public for a number of reasons. First, this is another glorious opportunity for this House to showcase to the Kenyan public the importance of constitutional accountability and fidelity to the law. The Senate, by virtue of Article 81 of the Constitution and Section 33 of the County Government Act number 17 of 2022, has a solemn constitutional duty to undertake the process of removing or not removing a governor. In our view, that process is a delicate balance you must maintain between it seen as a whitewash or as a witch hunt. And it's my humble submission before this august institution that you have an excellent opportunity to showcase to the skeptical and disillusioned Kenyans that are not happy with our institutions of governance. Mr. Chairman, during an era when the institutions, whether it is the judiciary, the executive, and the legislatures, are floundering and grossly underperforming, and when the citizenry of this country have shown great dissatisfaction and happiness with the three co-equal arm of government, this committee has a special duty and obligation for the common man and woman in rural Kenya who believe that the rich and powerful are simply unaccountable and operate in an atmosphere where the rule of law has taken an indefinite leave of absence. You have a duty, Mr. Chairman, and your committee to reestablish their faith in our institutions, and that, in my humble submission, is priceless. We are not saying that you swallow our case and evidence hook, line, and sinker, but we are pleading and respectfully petitioning this august institution that you apply the law as it should and hold the governor of Wajir to a constitutional audit and accountability so that his reign comes to an end. Mr. Chairman, the trial and the motion that triggered it couldn't be more authentic and genuine. It's as a result of the masses and ordinary folks in Wajir who have revolted and risen against the rule of the governor. It's a local MCS in their rural stations in Wajir in a bold and brave act of selfish sacrifice that initiated this process. And I want this committee to appreciate that this process has no big wig, it has no big man, it has no sponsor. It's the MCS from Wajir that has triggered it. It's not driven by the national politics of this country. It's not even influenced by the clan dynamics of Wajir. This petition, Mr. Chairman, is both clan and political neutral. It is because of the accountability of the governor, the impunity of the governor, that could not be tolerated anymore by the petitioners and the grassroots members that they represented, which triggered the seismic political change in the ecosystem of Wajir and even the larger northern Kenya. Mr. Chairman and honorable committee members, we are confident that when we take you through the evidence and show you the graphic but scary malfeasance, incompetence and corruption of the governor of Wajir County, we are confident that you will reach the inescapable conclusion that His Excellency, Governor Mohamed, must be taken out of the political equation in Wajir. In fact, we boldly submit that if the Senate cannot remove this, it will probably not remove another governor. The evidence is overwhelming. The evidence is indicting. Mr. Chairman, I know you as my former chairman, that you and some of your members have excellent training in law, but I will just tell you that when you go through this evidence, the issue that should come to your mind is the legal doctrine in the law of tort that is habitually pleaded in personal injury cases comes to my mind, and that is, Mr. Chairman, res ispa liquato. The facts speaks for themselves. You really don't need to prove it. It is so obvious. It is there ex facie. Mr. Chairman, just like your committee, we are very conscious of the fact that this is not a criminal trial. Rather, it's a constitutional process that is quasi-judicial in nature. So even though we are confident that our evidence can sustain a criminal trial and satisfy the standard of proof of beyond a reasonable doubt, that is not our brief this morning. We are not doing a criminal trial. This is a constitutional process or adjudication, and the standard of proof hovers in the neighborhood of the balance of probability. Mr. Chairman, again, I would like to impress upon your committee that it's not a question of quantitative, it's a question of qualitative. If we show that 1 shilling, 1 dime was stolen or misappropriated, that is enough for his removal. We don't have to show you that billions were stolen or hundreds of millions. It is the breach of the law, the act of impunity that led to the loss of that 1 shilling that should be enough for you to remove him. Mr. Chairman, before we give you a snapshot of the evidence that we will lay before the committee and the factual metrics that define the case of the County Assembly of Wajir, let me comment about very briefly the governor as a witness and his decision not to appear as a witness in the most important trial of his political career so far. We are conscious that he has appeared before you pursuant to Rule 6, but we emphasize, Your Honor, we emphasize, Mr. Chairman, that his refusal to take the witness stand is pivotal in the determination of this, and it is very critical in the deliberations you make. Although we refrain from submitting that a negative inference can be drawn by his refusal to take the witness stand, I submit, Your Honor, Mr. Chairman, that you must take notice that, as usual, when the governor is told to account for his omissions or acts, he always skips his trial. He never participates in his trial. Your Honor, there is one issue I just would like to emphasize, and this is the fact that if you look at the history of the defendant and his participation in judicial processes, this is a witness who persuaded a court that his lack of education is not very important, and a court of the eminence and standing of the Supreme Court. And when I argued that matter before the Supreme Court, Mr. Chairman, I impressed upon the court the famous case called Dred Scott versus John Sanford. Is an 1857 case of the U.S. Supreme Court, which declared that a black man is a chattel and is not entitled to freedom and will never be a citizen of the United States of America. I impressed upon the Supreme Court that they have a similar situation. And if they rule that the governor does not need to have a university education, the same way Dredd and Scott damaged the standing of the Supreme Court, that case will damage the Supreme Court of Kenya.
Chairman,
Yes.
if I may perhaps object at this point.
Yes, Council.
I have listened very keenly to Leonard Senior making his opening remarks. But with tremendous respect to Leonard Senior and this committee, he seems to be settling a personal score with the governor. The issues of the Supreme Court and what was submitted and what the Supreme Court was persuaded and not persuaded surely cannot form the subject matter of an opening opening remarks in respect of an impeachment trial. Those are personal views, and Leonard Senior is not a voter, is not a citizen of Wajir County.
You know, I think it's beneath my learned friend to make that. There's nothing personal about this. I'm referring to one of the most important cases ever decided by the Supreme Court of Kenya. That is uncomfortable with that. Doesn't mean anything to me. It's for him to sort out it. Can I conclude, Your Honor? I'm about to finish.
Senior Counsel,
Yes.
we will allow you to proceed, but try as much as possible to limit your opening remarks to the issues before us. We may not have a lot to say about.
Interpretive decisions institutions make have historical implications. And that is why I'm saying that when I give the case of Dred Scott and the case of the governor in Supreme Court, there are certain decisions that institutions make that they regret for the rest of their lives. And that is the danger I'm alluding to in this matter. But my Lord, Mr. Chairman, as a deliberative institutions, you are seized of interpretive powers under Article 10 of the Constitution. When you are determining this matter, you are interpreting the Constitution, you are interpreting the statutes, and certain values that are captured in Article 10 of the Constitution have a very important ramifications for your part. Mr. Chairman, we are calling 3 witnesses in this matter, and we have deposited their witnesses and statements. The first witness is Mr. Abdullahi Isaac. He is the MCA for El Nur Tula Ward representative. He is the author of the notice of motion dated 19th April 2021 that triggered the impeachment process. We will take you through his evidence first to show you the process from a constitutional law perspective was of high integrity and followed the letter of the law in all aspects. Mr. Chairman, he will take you through the facts that inform the case. The breach of Public Finance Act that is completely ignored in all dealings in the county government of the governor. This act, in my humble submission, is the bedrock of accountability. When you break this act, like the governor has preached in all aspects, you can't have any regard, or you don't have any regard for public finance. He will give you a detailed breakdown of each and every breach that occurred. He will show you that the process was not even Byzantine, it was worse than that. He will show you that billions were lost, some unaccountable, some nobody knows where they have gone. He will show you that even something so simple like giving the annual address so that you can share the vision and the hope of your county, the governor has refused, notwithstanding the statutory provisions that underpin such important exercise. He will take you through the budget and the accounting process. He will show you that even a budget for 1 year, when the assembly passed, the governor just changed the whole budget so that it can suit certain issues of dynamics for him. He will show you that Governor Mohamed thrives in an opaque, secretive system that has no checks and balances, that has no accountability, and is defined by impunity and immunity from prosecution or the reach of the law. The second witness, Mr. Chairman, is Shuaib Barre Abdi. He represents Div Ward. He has an affidavit. He was the second person who seconded the motion before the assembly. His evidence zeroes on the First Lady, Her Excellency, Mrs. Khaira Umar Maalim. And we are very respectful, Your Honor. We don't want to go very personal with the First Lady, or because she's a mother, she's a wife, and we have been very careful to circumscribe the evidence we are giving to ensure that it only touches when, or it's only relevant when it interacts with public finance and public accountability. But according to the evidence by Mr. Shoaib, Madam Khaira is no ordinary First Lady. She is not power behind the throne. She sits on the throne. Shoaib will take you through his evidence and give you a snapshot of her reach, that how her tentacles are deep and strong in the affairs of the county. In few months in 2018, and we will share with you, we'll share with you the chart, we will show you evidence of about 28,825,000 that she received as kickbacks in contracts that are awarded by the government. It is astonishing, Mr. Chairman. It is breathtaking, but we will share that evidence with you. Lastly, Mr. Chairman, we will share with you the last witness, Honorable Hussein Abdurrahman Dahir. He is the representative of the ward. He has two affidavits, one on bending pills, 2 million shillings of work done, not paid, no money. Where that money has gone, he will share with us. And the other one, affidavit, is held. A staggering 2 billion was spent in the last 3 years on the health sector. There is nothing to show that. Mr. Chairman, when we share this evidence with you, we will persuade you and your committee that the only option you have in light of the evidence we show you is to recommend to the plenary of the Senate that His Excellency Ambassador Mohamed's tenure as governor of Wajir should come to an ignominious end. I'm most obliged.
Very well. Thank you, Senior Counsel Ahmed Nasir. And thank you for keeping to time. Counsel Nyamodi, you have some opening remarks to make?
Mr. Chairman, we do have opening remarks, and perhaps with your permission, I can address you without my mask from here. We will be sharing the time.
We will sanitize the dispatch. You can speak from the dispatch.
No, I will speak from the dispatch, but only for the purposes of responding to the chair's question. Yes, we have opening remarks. We wish to take about 20 minutes with them, and we will share the time equally between the governor, myself, and Mr. Ndegwa, and the governor will go first.
Thank you. So, Governor, you can take to the podium, to the dispatch. We have sanitized, but if you are not confident enough, you can speak with your masks on. But for your own comfort, we actually change the microphones after every speaker, so you are good. So you will manage. Councillor Nyamodi will give you 20 minutes. You see how you manage your client, yourself, and Councillor Ndegwa.
Thank you very much, Chairman.
The floor is yours.
Thank you very much, Mr. Chairman. Mr. Chairman, I wish to thank you and the committee for the opportunity to appear before you and present my defense on this matter of my impeachment. Further, Mr. Chairman, I take this opportunity to underscore the cardinal role of the legislative arms of the government, both of the national government, which is the Senate and the National Assembly, and the county government of the county assembly in exercising their representation, oversight, and legislative role as enshrined in the Constitution of Kenya and other relevant laws of the Republic of Kenya. Secondly, Mr. Chairman, the appointment of this committee by the Senate to hear and look into whether or not the allegations leveled against the governor of Wajir, which is me, can be substantiated as part of its constitutional mandate is a decision in the right direction. I'm optimistic that the committee will finally bring to an end the charges which are aimed to mar my personal character and integrity. Honorable Chairman, I would like to categorically state that I will fully cooperate with the committee and assist in establishing the truth and nothing but the truth, that the charges leveled against me as the governor of Wajir are unsustainable, are unsubstantiated, and cannot stand the scrutiny and threshold required for the impeachment of a governor. Honorable Chair, in the second generation of county government, Wajir County under my leadership has made tremendous progress in basic social and economic services with improvements in key performance indicators, as can be witnessed from the county statistics. Moreover, my government has been in the forefront in establishing a working relationship with the County Assembly of Wajir. A good example of that, Mr. Chairman, is that we have allocated 25 million Kenya shillings to each of the 30 wards in Wajir County since 2017. In other words, annually we are spending 750 million shillings to all the sub-counties for small projects that are for every, for all the 30 wards. Further, the county government under my leadership has proactively initiated equity projects by development projects in all these 30 wards. My defense submission will speak to this later during the proceedings. Mr. Chairman, I have reached a record as a career public servant for 45 years, long before some of these county assembly members were born, both within and outside the country. Some of my deployments include serving as a teacher, education officer, member of parliament, assistant minister, cabinet minister, ambassador, and now as the governor of Wajir County. It is imperative to note, Mr. Chairman, that during my industrious service, I have expanded service delivery in basic social services, and I have not been suspected or accused of any charges relating to violation of the Constitution and other relevant laws of the Republic of Kenya. Mr. Chairman, as you sit and adjudicate over this matter, it is my humble plea that the committee will have time to consider, to look at the unique circumstances the Somali community, where I come from, finds itself in its decision-making and formation of governance, that is formation of the government at the county level, the structures in all the counties in this region through negotiated democracy. I believe the allegations contained in the impeachment by Wajir County Assembly is politically motivated with malice and witch hunt. Finally, Mr. Chairman, my lawyers and witnesses will establish evidence, the circumstances that informed and influenced the impeachment. I have full confidence in the committee and its findings. Thank you very much, and God bless you.
Okay, thank you, Governor. You may resume your seat. Council, I hope you get guidance from the timekeeper as to how many minutes you have. Okay, proceed.
Mr. Chairman, members of the committee, the governor has spoken extensively about the issues arising from Wajir County and the issues that he believes are important in respect of this impeachment motion or these impeachment proceedings that he now faces before this committee. Mine really is just to emphasize a few issues about the state of the law that governs the process of impeachment. And I believe it is important for me to make these brief comments about the law because, as I am sure you require no reminding, impeachment is a political process enabled by the Constitution. It is politics enabled by the Constitution. And the provisions for impeachment in respect of governors are straightforward, and they are to be found in Article 181 of the Constitution of this Republic. The grounds for impeachment are found in particular in Articles 181, 1A to D. And I'm sure when the committee retires to consider your decision in this matter, you will be guided by those provisions of the Constitution. But in respect of the motion of impeachment that is before this committee, the grounds for impeachment are to be found at Article 181, 1A and 1D. And they are really very simple and straightforward. The governor is accused of gross violation of the Constitution, and he is accused of abuse of office or gross misconduct. Mr. Chairman and members of the committee, I submit or I state that the word gross will be of cardinal importance when you retire to consider your decision in these impeachment proceedings. And I say so because it is the responsibility of this committee to determine whether the evidence that will be led on behalf of the County Assembly of Wajir, if indeed it does disclose any misconduct, or if indeed it does disclose any violation of the Constitution or the law, whether that violation, and I don't say there is any, whether that violation is gross. The second issue that I wish to request this committee to bear in mind as you retire to consider your decision in this matter is the context of the evidence, the context in which the evidence arises. Are these ordinary transactions? Are these ordinary relationships between the county executive and the county assembly? Or do they disclose any misdeeds or any gross violations, of the Constitution or of the law, or any gross misconduct by the governor of Wajir County? And I'm sure if you apply your minds properly to the provisions of the Constitution, especially the ordinary English meaning of the word gross, and thankfully there is guidance from the courts of this republic as to what amounts to gross in terms of evidence, you will come to the right conclusion. Thank you very much, and I will donate the rest of the time to my learned colleague, Mr. Ndegwa Njiru, to conclude our opening remarks.
How many minutes does he have? So Ndegwa, you have 7 minutes, Council. Thank you. Please, can we have the change of mics? Sergeant at arms. Okay, Council, proceed.
Mr. Chairman, you are being invited this morning to find the governor of Wajir County culpable for issues of gross misconduct, violation of the Constitution and in the law. Mr. Chairman, you'll be invited to look at the question of the threshold and the issue of the nexus between the issues being complained thereof and the conduct of the governor and the functions of the governor. It's not lost of us, Mr. Chairman, that Section 30 of the County Government Act clearly indicates the functions of the governor who is before you. Mr. Chairman, we'll be inviting you to juxtapose the provisions of Section 30 as against the issues being complained hereof. Mr. Chairman, this House has enacted a litany of laws, among them the Public Procurement and Disposal Act, which, Mr. Chairman, forms the basis of the complaint as against the governor. We'll be inviting this House at the fullness of time, Mr. Chairman, to look at various sections, and most importantly, Section 55 and Section 45 of the Public Procurement and Disposal Act, and scrutinize the issues complained hereof. It will surprise you, Mr. Chairman, that the County Assembly of Wajir is inviting you to find the governor culpable for mere theatric issues. Theatric issues in the sense that the allegations do not meet the threshold as established in the case of Governor Wambora, Civil Appeal 194 of 2014. Mr. Chairman, we had the opportunity of arguing that case with my land senior counsel, Mr. Mohamed Nasil, and it's very clear that the threshold was established in that case. And the ratio decidedi of that case, Mr. Chairman, was that it is not every allegation, every breach that can culminate to finding of the culpability of the governor. Again, Mr. Chairman, this matter was argued by my senior learned friend, Mohamed Nasil, before the Court of Appeal in Nyeri. That is a civil case number 21, again of 2014, the case of a Governor Wambora. There was a question of nexus. How do you connect the allegations facing the governor with the functions of the governor? We shall tender evidence at the fullness of time to show you that there is no nexus that can lead to the impeachment of a governor. Mr. Chairman, though Article 10 calls for the accountability and transparency as one of the overriding doctrines in matters of governance of this country, the question is, can an individual purport to each hand in the name of calling for accountability? Do we have the standards upon which a person can be said was accountable or was not accountable. Mr. Chairman, we'll be inviting this committee to set a precedent that lays bare the standards and the threshold upon which an individual, an innocent man of the governor's caliber, can be held to account. Mr. Chairman, it is said that it is better to acquit 100 convictees other than having a conviction of one innocent man. The man before you, Mr. Chairman, is an innocent man. Is a man who is facing a fishing expedition prosecution. We urge you, Mr. Chairman, to protect the integrity of the man before you. We urge you, Mr. Chairman, to uphold his dignity as prescribed under Article 29 of the Constitution. Mr. Chairman, if an ambulance lacks fuel, is it the work of the governor to fuel that ambulance? Mr. Chairman, can lack of fuel of an ambulance form the basis of impeachment of a governor who is democratically elected? Mr. Chairman, were the people of Wajir County involved through the public processes, public participation, as enshrined under Article 196, Clause 2D? Were they involved? Did they participate? Do we have evidence of their participation before you? Can a mere person, driven by ulterior, scandalous, vexatious approach, have the governor convicted? Mr. Chairman, the governor is accused of allowing unqualified professionals to handle the functions of procurement. Is the governor the head of the public procurement? Does he participate in the process of the employment? Is it true that the county assembly is not able to distinguish the functions? Are they lost in the mud? Mr. Chairman, we'll be inviting you at the fullness of time and the members of this honorable committee to consider the question of the function of the governor and the culpability. Mr. Chairman, this is not one of the impeachments that should have seen the light of the day. It's a petition, or rather it's a motion of impeachment that is scandalous, impeachment that is frivolous, impeachment that is meant to cause annoyance and embarrassment on the part of the governor. Why is the county assembly so much passionate by the failure of the governor to take the stand? Did they want to have a continuation of the matter before the Supreme Court? We are in a different arena. Mr. Chairman, abuse of office, gross misconduct. You have been told that there was one overall leader, the person of the First Lady of the county as a government of Wajir. Is there any evidence to show that she ever participated in decision making? Is the person alleging this aware that we have now moved from the roadside declarations to a situation whereby government policies and decisions must be in writing? Have they provided any writing to show that the First Lady made any decision on behalf of the county government? We shall be able to provide evidence, embarrassingly so, to the contrary. Mr. Chairman, we urge you to grant us an opportunity to show you that the governor has not in any event usurped the powers of the Public Service Board to an extent to protect the integrity of the county government, that the governor stood evidence as against these individuals in criminal case number 47 on 2018 before the Milimani High Magistrate Court. The governor appeared as a witness. Why did the governor appear as a witness in that case as against officers? Because the governor believes in the doctrine of good governance. Okay. The governor believes in accountability and transparency.
Your time is up.
Thank you, Mr. Chairman. We invite you to grant us time. We have about 6 witnesses who shall persuade you to hold to the contrary. Much obliged.
Thank you. Very well. I think that brings to an end that session of opening remarks. And it's now 1 o'clock. As I said, we'll retreat of a lunch hour so that we can make our ruling on the request by the County Assembly that we summon 4 witnesses. We will also consider the other preliminary issues that have been raised, including the admissibility of the letter by Ahmed Nasir Abdullahi and Company Advocates dated 11th of May 2021. We will also look at the issue of the competence of the motion that is before us. We will also look at the issues of the affidavits CA4 and C8, the implication of them not having been part of the evidence before the County Assembly. And we'll also give direction on the inclusion of affidavit marked as CA7 and the issue of the motion that is pending before Wajir County Assembly. Courtesy of your taxes, there is lunch that will be offered to all of you at the main restaurant. It's in the form of takeaway, so you can take away to your respective holding rooms. I know others like Governor and Senior Counsel Ahmed Nasir are fasting, so you will spare our tax money by not taking lunch. But the rest, you can have your lunch at the holding room. We will convene back at 2 o'clock to proceed with our ruling, and then the County Assembly can start adducing their evidence. We adjourn to 2 o'clock. Thank you. Senators, we meet at the launch. Senators, we meet at the launch.